The law is complex, but it doesn't have to be a mystery. We are talking legal literacy, not advice. So don't worry, you're not getting an invoice. I'm Simon Jenga, and welcome to Simon Says. Today we are talking about a couple of different techniques we can use in wills for more complicated family situations. In New Zealand, there are a number of blended families. And what we're about to talk about is particularly applicable in those circumstances. So, what you have is you have two people who are living together and they have, let's say, children from previous relationships. When one of them passes away, they don't want half of the assets to go walkabouts to those kids straight away. But they do want their kids to receive something. And they don't want it to be that the survivor in 10 years' time has married someone else, either benefits that person with everything or gives everything to their kids. It's not about judgments or people being naughty, it's just about practical realities. So that's what we're talking about. Two people, separate children, they don't want the assets to be split when one of them passes away, because then the survivor might not be able to afford a house on their own. They might not be able to afford the comfort or the level of lifestyle that they've enjoyed while they've been together. So what they want to achieve is that the survivor can have the benefit of all of the assets for the rest of their life or for a certain amount of time. And then when they pass away, or whatever that trigger point is, then the assets are going to go sideways. The first person that passed away, their share goes to their kids. The second person to pass away, their share goes to their kids. And that's how it's divided up nicely between the two families. Keeps a bit of control between the two people, puts a bit of restrictions on the survivor because they don't just get everything. So in a simpler structure where it's mum and dad and they have their own kids, let's say, they might just leave everything to each other. The survivor has control of everything. And that's really on the basis of the expectation that they will benefit their joint children together. So maybe there's a lower risk that everything will go to one side. Now this occupation right, as it's commonly referred to, is also referred to as a life interest. Now the reason that we tend to not use that term as much is because it doesn't necessarily apply for life. So often it'll say something like, the assets are held for the benefit of the survivor for the duration of their life, or until they remarry, enter into a civil union, or are in a de facto relationship for at least 3 years. It's a fairly typical restriction on an occupation right or a life interest, which means that it's not really for the rest of your life necessarily. Now the other thing in terms of duration is that it might be those standard, more common restrictions, but it also might just be a time limit. It might be 5 years from the date of death that the occupation right persists. So it can be whatever you want it to be, and that really comes down to what is applicable and relevant for your particular set of circumstances. The other major parameter with an occupation right that changes is what assets are subject to the occupation right. And what I mean by that is it your entire estate, or is it just, say, the family home? And that is fairly typical. Family home is divided into two half shares, and then that's the subject of this occupation right. And then when that occupation right ends, half the property goes to this side, half goes to this side. But then all the other assets, bank accounts, chattels, vehicles, they all just say go to the survivor. And that's quite a clean way to minimize the expenses of the estate, but also preserve a little nest egg for both sides of the family. Now, it doesn't have to be a property that is the subject of this occupation right. It could be a particular investment fund. It could be a particular set of bank accounts. It can be anything, but the critical thing to remember is that if anything is jointly owned, it's going to automatically go to the survivor. So, for example, a joint bank account can't be subject to an occupation right or a life interest, because on death of the first of you, it's already passed to the survivor fully and absolutely. So it's only in circumstances where you've got assets that are either 50-50 owned or an asset that is wholly owned by one party. And although I've given the example of a blended family with mum and dad, kids from different relationships, that's an example of when it is applicable, but it can apply in other circumstances as well. It's not just limited to that scenario. So if you're listening to this and thinking, that sounds like something that would apply to me, but I don't have kids, so maybe it doesn't work. That is the kind of thought that is worth exploring with your legal advisor to make sure that you understand what the options are that are available to you and how your legal structure might benefit from something like an occupation right, a life interest. Now, the other provision that goes hand in hand with occupation rights is what we call mutual wills. Now, mutual wills are where two people have decided to make specific distributions in reliance on the other person doing the same thing. So, for example, with our occupation right, we've both agreed that our half share in the property, that we're going to give each other a life interest or an occupation right in that half share. Now, we also want it to be a restriction that neither of us can then change our wills, because we're really relying on the fact that we're going to be able to live in the property when the first of us passes away. And that's what the mutual will agreement within those wills is doing. It's saying, you can't change this provision in your will because we've both agreed that we're going to put it in our wills together. Now, unlike standard contracts where you do one document and you both sign it as an indication that both parties have reached agreement as to specific terms, the Wills Act 2007, specifically Section 30, if you want to look it up, it outlines that by executing your two wills and by demonstrating, preferably in writing, that you are executing the wills on the basis that you're relying on each other having those same terms, then that is going to lock in those provisions in your respective wills. So there doesn't have to be a third document recording that you have agreed. Now, in some circumstances, we will look to do a third document for absolute clarity to make sure that it's crystal clear, but it's not strictly a requirement in a lot of circumstances where people are wanting to lock in the provisions of their wills. The other thing that we can do is that we can restrict only specific distributions within a will. So it doesn't have to be that every single distribution under a will is restricted. We can limit it to specific parts. And sometimes that's appropriate. Sometimes it's appropriate to have the whole thing restricted. It's really going to come down to your specific circumstances. And that's something that we work through in terms of the bigger picture of drafting a will. So we're looking at, should there be any restrictions? Is it in relation to an occupation right or a life interest? Is it in relation to some other provision where you're each wanting to provide a gift back to your parents or to your neighbour for them supporting you through a tough time or supporting you financially when you couldn't afford to pay your mortgage? It could be any myriad of reasons that you're wanting to put a restriction in your will. And the critical thing is to turn your minds to how that's going to impact the survivor in particular if they want to change their will down the track, and making sure that you are comfortable that it's reasonable, the restrictions that you're putting in place. And actually, reasonable might not even be the right measure. Desirable. Is it what you both want? Looking into the future, is it likely to be what you would want in certain predictable scenarios? So today, Simon says, if you have a complex family and you need to take into account money going in different directions, people benefiting straight away while other people benefit later, restrictions in your wills to make sure that someone else, normally a partner, is doing the same thing as you, then now's the time to review your wills and make sure they're doing what you want them to do with your trusted legal advisor. For more legal insights, check out our other episodes, subscribe to our channel, and remember, at LOA Law, we are good lawyers for good people.